All right, let's bring the jury back in then. All right, let the record reflect all our jurors are back in their seats. I'm handing the bailiff, sheriff, the verdict pack, hand back to the person entering. And at this time, ladies and gentlemen, we'll resume your deliberation. You'll be at ease.
What's at ease? Your Honor, we have a matter, we have an objection to my subpoena, and we have folks from the police department that, while we're all at Your Honor's disposal, and I see we have the police attorney, we have Deputy Chief Smith, and we have an objection to the subpoena, so whatever Your Honor's wishes are to do at this time or not to do at this time.
Alrighty, well we've got the jury, let's handle whatever we need to handle. All right, as I understand, where we are, Mr. Charnes had indicated that there was a subpoena issued to be served on the Chief of Police of Durham County, Durham Police Department, Durham County, the Durham Police Department, that when we got through the procedure, the subpoena, the indication was that the subpoena was handed to a sergeant at the Durham Police Department, that there was an indication that the subpoena was deemed not to be served. There was a subpoena, or the identical subpoena, I'm not quite sure, I don't quite recall that. The subpoena was then sent to the Sheriff's Department to serve on the Chief of Police, but the date, the time, not the date, but the time that was listed on the subpoena was, had already passed, at least the time that was, the initial time listed on the subpoena had already passed. By the time the subpoena was delivered to the Sheriff's Department, it was returned by the Sheriff's Department as unserved because that time had passed. There was some language there about period that time, a week to week, until the case is complete. But I found that that was not unreasonable for the sheriff to, under all of those circumstances, to have not served the subpoena, deeming it expired or whatever. Another subpoena was issued during the court here. Mr. Charnes indicated that he had walked over and given it to some deputy chief or assistant chief or whatever that position is, and wanted to put that on the record. And then that's where we were. It was to, as I understand it, the subpoena form said for the chief of police to appear and produce certain records at 2:30 today. And that's all really, that's where we are. Did I miss any of that? Just bringing Ms. Smith up to kind of date with things that have transpired up to this moment. Did I miss anything?
No, Your Honor, and this would be also a good time, since we have folks from the department, this process of serving sergeant of the Durham Police Department in this building, the process that's used when you go to the Sheriff's Department to serve a subpoena on police employees, we're told to serve the sergeant. So the sergeant is in back where the district attorney has space behind the traffic court in this very building. And that process always works. It's also worked in other political cases that were controversial. For some reason this time it didn't work. And the police department, unlike the custom and the agreement between the sheriff's department and the police department to honor those subpoenas, which is a convenience to the city. They know about subpoenas immediately. So whatever their agreement was, they broke that agreement, and that custom of doing that in this case, and I can't read behind their motives, but it's pretty obvious why they didn't want to accept the subpoena. But in any event, I saw the deputy chief in the crowd and decided that this was a great opportunity for the city not to avoid the subpoena. That was important, that I wanted served, and wanted this documentation that I consider Brady material material under Kyles v. Whitley the prosecution should have provided, but instead of having that argument, which is a little late for that, the Sixth Amendment being a powerful force in this court order in the subpoena to gain information to use either in cross-examination of witnesses that appeared in this courtroom or to put on a defense case. So it would be both information that could be used in cross-examination. So again, it's the Sixth Amendment right through the 14th, the right to counsel, the right to actually secure witnesses to effectively cross-examine. So what is asked for is all warning tickets issued by Officer Kelly Stewart from 12/18/2011 to and including 12/18/2012, and then all training materials for Officer Kelly Stewart. And the objection, and Your Honor, if you have a copy of it, you can see it's personnel privacy argument. And just like in many of our statutes where things are protected, there's the safety valve of if Your Honor finds certain things in order of a court of competent jurisdiction would allow those things to be released. How a warning ticket is a personnel record is really beyond me. It's given to someone in the public. Are there any, I guess I just received this objection just moments ago and I read it. I don't see where they distinguish between the warning tickets and the training materials. Maybe there aren't any warning tickets, which actually would be something significant since the officer testified about he was going to give my client a verbal warning. And so whether he's ever given in that prior year an actual written warning, which would be some evidence that a stop or interaction occurred, and then we could go back and see on those SBI 122 forms, is he actually filing those forms correctly? Is his stop percentage of African Americans 76%, or is it 80%, or does he only stop African Americans? So that's an important point in this trial. It's something we argued, something we presented, something we cross-examined about. So it's a point that is not a collateral point. As far as training materials, our argument, both in cross-examination and during closing, an important point is Officer Stewart doesn't follow the rules. So was he not trained properly? Going all the way back? This would be some indication that if he's following the same rules everyone else is and was actually trained in the same way, that he just doesn't follow the rules. And that's him, and it's not the city failing to train him. So again, our argument is this is Brady materials, Kyles v. Whitley material that the prosecution should have had and made available to us, considering what this case is about. So this isn't some collateral issue that wasn't important. It's very important, and the reason I wanted to make sure that someone doesn't avoid my lawful subpoena by trick or artifice, that I want these records, obviously the jury's deliberating. The purpose now is to put in the records, seal these up. Either I get to look at them so I can help out an appellate attorney if there is one, or not. That's up to Your Honor. But to seal these records for appellate purposes. So an appeals lawyer can say, here's what Charnes didn't have to cross-examine or make a decision whether to put on evidence, which we didn't put on evidence. If we have this, would that make a difference? So this appellate lawyer, speaking to the future through the court reporter in this time travel that we have here, to look at this and make a decision, just like the internal affairs records that are in there. It's something an appellate lawyer may find valuable or not. But as I explained yesterday, Your Honor, the appellate defender, chief appellate defender Staples Hughes, is someone, he assigns me appeals. And he emailed me about an earlier issue, and he said, absolutely, you have to put under seal things you don't receive. So I didn't receive this in a manner so I could cross-examine someone, and it may be there's all sorts of objections to this, and it should be quashed, but even if it's quashed, my offer of proof is the very thing I'm asking for. So Your Honor may say, well, Charles, you waited too long, I'm not going to give it to you. It's still, I'm asking that as an offer of proof it be sealed up. And I guess my punishment is I don't get to see it. Or not punishment, but the end result is I don't get to see it. I would like to see these materials because that would be helpful to guide an appellate lawyer. But in any event, whether you grant this request or deny it, to make a record, these materials should be placed under seal if you find them to be personnel records. So for appellate purposes, an appellate court, an appellate attorney can look at these materials and make a decision. I'm not going to go behind why the police chief is in the paper, in the News and Observer through a spokesperson, or in the Herald directly being quoted as saying, oh, I didn't get a valid subpoena. Well, he knew about the subpoena, whether he was in town or out of town. They got it on Friday. So this idea, it's a last minute thing yesterday, is actually not entirely accurate because they knew about this since Friday. There are other people over at the police department. It's not like they don't know me. I've been litigating on the other side of them for 32 years. I'm not going to go into the history. I have my CV that's part of the file now based on other issues. So you can see the appellate history of cases I've handled for people, police misconduct cases, where I've represented officers, I've represented police employees. We have a Fourth Circuit case that we went up to the Fourth Circuit. The city spent millions on the defense of the case, and I'm representing police employees. The city wiretapped them. There's a Fourth Circuit case. So the history that I personally have, why they might not want to honor my subpoena, why something is different here, and we're not going to use the sergeant, we're beyond that now because I served a valid subpoena on the deputy chief when he was here in the crowd. So I use self-help methods, and they're here, and Your Honor, the decision whether I get to see it now isn't the biggest issue for me. It's just that we follow the procedure that the appellate defender is asking to follow, and it is the proper procedure. That if I don't get to see these materials now, that they be sealed up in any event, whatever your ruling is for appellate purposes. So under seal or not under seal, but training materials being personnel records it's kind of a interesting concept. How he was trained is somehow a personnel record. It's not individual to him. Everyone received this training. But the reason it was so important in this case, the officer violated the general orders of the police department, admittedly. So the issue of how he was trained is certainly central to this case. And the case is over, but it's not over if my client's convicted and there's an appeal. So I would ask whatever Your Honor's ruling is that in the end that these materials be sealed up, placed in the court file, either under seal or in some other method, but we still don't know. We don't have the answer to, are there any warning tickets, written warning tickets? If it's a verbal warning ticket, of course, my subpoena is useless. As to that, are there any written warning tickets? That's something, as an appellate lawyer, if I was looking at this case, I would want to know. His training materials, I would want to have those as well. So that's my argument why this is not something that those trainings, they just keep coming. If I sit down, they may stop. Let's see. No. Okay. So that's basically my argument. If you have questions, I'm happy to answer them. But I just, I'm duty bound to do, I'm doing the best job I can as a court-appointed lawyer for this young man, and fighting as hard as I can fight and doing everything I can. So if they won't serve my subpoena, I'm going to serve it myself. I have eyes. I can look around the courtroom, see who's here, and I can read the paper and see what the chief says about the subpoena that he said he wasn't properly served with. So that's,
One of the questions I asked y'all to check in on, because I have not been able to locate any legal research, was whether a subpoena, whether a proffer has to be connected with testimony that would be offered at trial but was excluded, as compared to the discovery of Brady materials. And did y'all find anything on that?
I did not, Your Honor, and just again, all I can tell you is what I do as an appellate lawyer and what I'm told by appellate lawyers above me in the food chain is anything in controversy, put it in the record, make a proffer, and I can't make a proffer other than state what I'm trying to get. So here, the only way to make a proffer is to put it in the record. There's no harm if it's sealed up. If you find it is personnel records, then if it's sealed up, it's just like those internal affairs records that in the first time in 32 years I didn't get it. And Your Honor, that wasn't your ruling, that was another judge's ruling, and but they're sealed up. So if that's in error and there's an appeal, then something can be done about it. Same thing here. So it's the same argument, and I would argue that the Constitution requires the proffer be sealed up in the same method. So the 6th through the 14th Amendment, I guess Davis versus Alaska, United States Supreme Court, that whole question, could you ask someone about their juvenile conviction? So this is different. They claim it's a personnel record, I claim it's not. Is it? Well, it doesn't matter. At this point, it has to be sealed up so an appellate court could look at it. Otherwise, even when I litigate with the FBI and CIA, sometimes they have secret affidavits. They go back with the judge, and it's top secret, and the judge looks at it. And they say, well, we can't tell you what it's about. Well, it's always kind of strange to be sitting here at a table in federal court, and the judge is back with the FBI, and they have a top secret affidavit that I don't get to see. And they tell me how many pages and what years. In one case, it was William O. Douglas. They opened his mail to the Soviet Union. But they wouldn't tell me what's in that letter. They said it was still top secret from 1966. So the same thing applies here. That would go up to an appellate court for review. I wouldn't get to see it. It may be whatever, if you make a decision that this is sealed up, the appellate court would get to look at it, but the appellate lawyer, if there was one, wouldn't get to see it, and I may not get to see it. It's just very important that the Constitution, in this case, I would argue, requires the proffer to be sealed up for appellate review purposes.
Well, I'm going to interrupt y'all and ask y'all to step away from the table. Keep hands on the side and just we have a question from the jury. I'm going to address that first. All right, at approximately 2:50 p.m. today, the bailiff handed me a note from the jury that reads as follows. The jury requests to review the transcript of Officer Stewart's testimony.
Do we have that
I'm
technology?
trying to remember how long Officer Stewart testified. But it's just not something you can put together on a moment's notice, and the court reporter and I have had this discussion about reading back testimony. We just had a discussion about that, and I said, well, you know, your initial transcript is compared to like the audio of it and cleared up. It's extremely difficult to go back until later, much later, to type out a transcript of someone's testimony. So I'll hear from each of you as to what you think my response should be. It just comes to mind immediately that I know court reporters are doing other things too, but sometimes it takes a while to get a transcript for people. So
I'll sign for you.
anyway, let me hear from the state and defense as to what your suggestions are. I'll make a final decision, but
Well, Your Honor, my first question would be if this were even possible, or perhaps this would be a question for Madam Court Reporter, what would that time frame look like if it were possible?
Madam Court Reporter, can you type and speak? We're going to pause everything right now. We're off record, so that the court reporter is not having to record anything. If y'all want to have a conversation with the court reporter, y'all go right ahead while I look up something else up here.
How's it going?
Thank you.
I don't hear a train right now.
If y'all want
Is it possible?
Is it to get a final? By when? And it has to do with whether the judge is willing to sign an order for an expedited transcript.
Okay.
So by 5 you couldn't have one?
No, by the morning after.
Wow, you were there.
So that's pretty amazing. You could have one by tomorrow morning.
I worked all night, so
Sounds like a bad night.
it must be a long night for me. And the judge is gonna have to sign an order for me.
All right, my notes reflect that Mr. Stewart began testimony at about 3:25 on August 3rd. And it, you know, we had some starts and stops because of some things that needed to be heard outside of the presence of the jury. But essentially concluded about 3:04, that's approximate, on August 4th. So, the better part of today's testimony.
She's grimacing.
I know for the record she's smiling.
Um,
I always smile.
So, we're going to pause again. We're not on the record, I'm not going to be a part of this conversation, but y'all now can have a conversation with the court reporter about transcript of that link if I grant the motion. In the meantime, I'm going to step down, I'll be right back, you'll be at this.
What's it is?
Sure. You just want the testimony, not the stuff in between.